So we're going to begin with voluntary consent. What is it? The knowledge of and genuine assent to the terms of a contract. So let's say I make a deal with you to sell my property in Florida for $10,000, and you agree. All the requirements are met. There's an agreement. There's an offer and acceptance. There's consideration, the bargain for exchange. It's a bilateral contract in exchange for promises. There's no legality issues. Let's assume you're of age, I'm of age, everyone has capacity, and there's no legality issues here. This is a contract that meets all of the requirements. But what if the property isn't owned by me? You find this out before closing. Can you get out of that contract? Yes, you can. Why? Because you lacked voluntary consent. Voluntary consent is lacking if one or more of the parties are mistaken about an important fact concerning the subject matter of the contract. In this case, it's the property. I don't own it. So a lack of voluntary consent exists if contract was entered into by fraudulent misrepresentation, undue influence, duress, or mistake. And we're going to go through each one of those. Okay, so that's the example I just went through. Lack of voluntary consent is a defense. So if I was to enforce my contract, you can raise the issue of voluntary consent. You did not consent to the mistake about an important fact. And I mean, I don't say it in the example, but if I knew that the property wasn't mine and I try and sell it, you might have a fraudulent misrepresentation case as well, but we'll get to that. In this case, it was a mistake about an important fact. Maybe I thought I did own it when the deed was shown it. I didn't own it. So mistakes. What do we have? Mistake must relate to a fact in existence at the time of contracting. Well, we all make mistakes, right? A mistake has a wide range of meanings. It could refer to a factual error, but it might include something like bad judgment, a rash decision, or a situation that just didn't work out well, right? For instance, you buy an ugly chair. You invest in your uncle's crazy enterprise. You drive to town when you should have taken the bus, right? Those are all mistakes. But in the legal world, the legal meaning of mistake is quite narrow. And in some instances, the courts allow for mistakes, okay? A party cannot just escape a disadvantage or a regrettable type of contract that resulted in poor judgment. You buy a painting for $10,000 and you're thinking it's worth $1 million, but in reality, it's only worth $8, okay? Incorrect prediction of the future events, that's not a mistake either. If you want to buy stocks and you hope that the market rises and it doesn't, you can't complain about it later. So mistake must relate to a fact in existence at the time of the contract. A mistake of fact. Unilateral versus bilateral. We've heard this name, unilateral and bilateral, in various types of contracts we've already been dealing with. So we have a unilateral mistake, we have a bilateral mistake. The unilateral mistake is one party's mistake, right? Bilateral it's a mutual mistake. So what's the key about mistake? The mistake involves a material fact, an important fact, not just some random fact, an important fact. In the example that I just gave regarding the property, it's the fact that's central to the subject matter, in that case, the ownership of the property. So do I have an example? Yep. Next example. Elena intends to sell her personal jet ski for $6,500. She learns that Mark is interested in buying a used personal jet ski. She sends him a text message offering to sell the jet ski to him. When writing the text, however, she mistakenly keys in the price of $5,600. Mark immediately sends Elena a text accepting the offer. Can she get out of this saying, oops, it was a mistake? She cannot get out of that. she made a unilateral mistake. It's a mistake towards one party, but the contract is enforceable nonetheless. It can only be unenforceable. Elena can only get out of this contract and be unenforceable when the party to the contract knows or should have known that a mistake was made. And 2, the error was due to a substantial mathematical mistake in addition, subtraction, or multiplication, and was made inadvertently without gross negligence. So in either one of these situations is when a unilateral mistake will be a defense, and they'll be allowed to deem the contract unenforceable. So in this instance, so in the example that we just did, if Mark knew Elena was selling her jet ski and was asking $6,500, and let's say her text was $2,500, but the market value is $7,500, do you think she has a mistake issue? Yes, she would be able to have a mistake. Well, I should say a mistake argument. Yes, she would have a mistake argument. With regards to the number 2, the error due to a substantial mathematical mistake, we see that in big contract deals, mergers and acquisitions, things of that nature where people are composing and transforming numbers. And sometimes an inadvertent mathematical mistake is made. A court will allow for that. The simple contracts we're talking about for this case, the party to the contract, if Mark knows or should have known that there was a mistake, then it's going to be deemed a mistake. All right, back to my example about the property. So I don't own the property. Can you get out of it? Yes, you can get out of it, because it was based on a material fact. Okay, the mistake involves a material fact. Just change those facts up though. Okay, what if I do own the land and we have a deal and you believe that you can sell the land to your neighbor for 3 times the contract price, which is why you entered this deal, but you later find out that your neighbor is not willing to pay 3 times. Can you escape contractual obligation with me based on your mistaken expectation? No, you cannot. What about this example? Seller sold a lakefront lot to a buyer for $500,000. The price was that high because it was luxurious and prime waterfront property. The seller knew that the buyer was going to build a luxury home on the property, and both parties believed that the lot was suitable for building. Neither party knew at the time of contracting that the lot was on porous and unstable land, and it cannot be supported by a building. So what do we have here? Can either party get out of this contract, given that the parties have a shared understanding for the purpose of the sale? This would be a bilateral mistake, where both parties are mistaken about the same material fact. Either party can rescind. So if the parties attached, if both parties are mistaken as to the same material fact, either of them can get out of the contract. What's the difference between mistake of fact and mistake of meaning? When a party disputes the meaning of a contract term, one party is mistaken as to the intention of the other. This is not a mistake of fact. There's some external fact involved. The interpretation is governed by a reasonable meaning of the words. So if there's a mistake in a meaning, it's going to be determined, that meaning will be governed by the reasonable meaning of the words involved. Okay? What about value? Mistake of value. Carrie buys a violin from Mary for $250. The violin is very old. Neither party believes that it's worth anything. Later, however, an antique dealer informs them that the violin is rare and worth thousands. Is this a bilateral mistake? Neither party believed it was worth anything. Is the contract voidable? Mistakes of value can be bilateral or unilateral. But either way, it's not a basis for avoiding a contract. How about Carrie buys a violin? Oops, I just did that one. Where both parties are mistaken, but the mistake is a mistake of value rather than an important fact. Like I said, market value is not going to be the basis for avoiding a contract. Concerns for future market value or quality of an object is not. Why do mistakes of value and quality have no legal significance? Why wouldn't they? Why does it matter? Because the value varies. It's a variable. So depending on time, place, and other circumstances, then an item can be worth considerably different amounts. So that's why the market value isn't going to be deemed the basis for avoiding a contract. So when the parties form a contract, this is key with relative to the value of the goods. When the parties form a contract, their agreement establishes the value of the object of their transaction at that time. Each party is considered to have assumed the risk that the value will change in the future or prove to be different from what he or she thought it was. So is this a good rule? Without it, any party who did not receive what she considered a fair bargain can argue it was a mistake, right? They always say when you drive a brand new car off the lot that it depreciates in value. So moral of the story, get good appraisals on your property. So then we have fraudulent misrepresentation. When an innocent party consents to a contract with fraudulent terms, the contract usually can be avoided because the innocent party has not voluntarily consented to the terms. Why? Why no voluntary consent, right? Why are innocent parties options? There's no voluntary consent because the person wasn't involved in the bargaining exchange. They used in some instance they were told a lie, and that led them to enter into a contract. We'll talk specifically about those, but what are the innocent parties' options when they have been subject to fraudulent terms? Well, they can either cancel the contract or rescind or enforce the contract and seek damages for the injuries that result in the fraud. And I have to be, I want to make clear here, fraudulent misrepresentation isn't a contract action. Someone wouldn't bring a breach of contract for fraudulent misrepresentation. Fraudulent misrepresentation isn't a defense, like in a mistake. The mistake is a defense. Here, they would have to bring a separate action in tort. You've learned about torts in the Business Law 1. But what you would need to show is there was a misrepresentation of a material fact, and that there was an intent to deceive, and the innocent party justifiably relied on the misrepresentation. So these three things would have to be present in order to establish fraudulent misrepresentation. This painting is a Van Gogh. You buy a Van Gogh. Someone tells you this painting is a Van Gogh, you buy it, but in actuality it was done by somebody else. That misrepresentation, that it was a Van Gogh painting, was made with the intent to deceive you, and you relied on it, and you bought the painting. So if those three things can be established, you'd have a case for fraudulent misrepresentation, and you would be able to seek the money back or get out of the contract if you haven't bought it yet and you find out later before the contract is performed. So let's talk about each one of these real quick. Misrepresentation. What is it? How about these? This investment will be worth twice as much next year. This car will last years. Are any of these misrepresentations? It must be a misrepresentation of a material fact. Do you think these are misrepresentations of material fact? What are these? Statements of opinion. They're not generally subject to fraud claims. These are statements of opinion. This car will last you for years. How about this example? At a dance school, Brian, an instructor, praised Audrey for her potential to be an excellent dancer. She contracted for more than $100,000 of dance lessons before realizing that, in fact. and she did not have the potential to be the excellent dancer that he claimed that he praised her for, can she sue for fraudulent misrepresentation? She possibly could do so. What would be the basis? Well, what would be the argument? Brian, in this case, as an instructor, has superior knowledge about dance potential. He made that statement to Audrey, one of the fact rather than one of opinion. Audrey, you have the potential to be an excellent dancer. Is that an opinion? If a naive purchaser relies on an expert opinion, they might be held liable. How about Tom, who contracted to buy a horse named Zorro from Joanne? Through various actions, Joanne let Tom believe that the horse was fit to ride in competition, but in actuality, it suffered from a medical condition that made it unsuitable for this use. Is that fraudulent misrepresentation? It could be. What happened here? What'd she do? She concealed omissions, wrongful concealing, omission of a horse's condition in this case. She led Tom to believe that the horse is suitable for competition and wasn't. So withholding or concealing could constitute misrepresentation. What if Tom asked Joanne if Zorro had a medical condition making him unsuitable to ride in competitions, and Joanne denied it? And she knew. That could also be a misrepresentation, fraudulent misrepresentation. So we have a misrepresentation of a material fact is fraudulent misrepresentation. Opinions generally are not subject to fraudulent misrepresentation claims, but if that opinion comes from an expert, it could be subject to a fraudulent misrepresentation claim. And we just learned that a wrongful concealing of a material fact could lend itself to a claim for fraudulent misrepresentation. What about misrepresentation of law? Mary has a piece of land that she's trying to sell to Jones. Mary knows that a local ordinance prohibits building anything higher than 3 stories on the property. Nonetheless, she tells Jones, you can build an office building 50 stories high if you want. Jones buys the land and later discovers that Mary's statement was false. Does Jones have a claim against Mary for misrepresenting the law? Can he avoid the contract? No, he can't. People are assumed to know easily that they can research state and local laws, and nowadays you can find it anywhere. You can find it on the internet. In general, mistakes of law does not void the contract, especially if you rely on a non-professional making that statement to you. So this was based on law. She knows that the local ordinance prohibits building anything higher than 3 stories on the property. Jones, as the buyer, could have learned that fairly quickly, and in this instance, Mary was not an attorney. But what if Mary is an attorney? There is an exception. If the misrepresenting party is in a profession known to require greater knowledge of the law than the average citizen possesses, then she might be held liable for fraudulent misrepresentation. So there's always an exception to the rule. Consider this example. Norman is selling his Honda for $1,000. Neighbor Joe test drives it around the block, likes it, and buys it. 2 days later, Joe drives it down to Albany, but only makes it an hour down the highway before the transmission falls out. He learns that the vehicle had suffered a traumatic incident related to the transmission. Norman's neighbor, Mary, tells Joe, oh, Norman's dog, while riding in the front seat, hit the gear shift into reverse, and when Norman was driving it down the road the other day, and it had some problems. So Joe sues for fraudulent misrepresentation for Norman's failure to tell him that the vehicle suffered such incident that could affect the transmission. Do you think that would have been an important fact in buying the car? And does he win? Norman doesn't tell Joe that the car had this traumatic incident with regards to the transmission. Does he win? Misrepresentation by silence. There actually is no duty to disclose pertinent information. But what if Joe asked specifically about the transmission and Norman denied? That would be concealing information, such as the horse incident example we had earlier. However, in that horse example, Joanne was holding herself out or showing conduct that would lead the buyer of the horse to believe that it was fit for competition. Here, Joe just bought a car from Norman, didn't really ask about the transmission, and Norman didn't have a duty to disclose, and there is no duty to disclose. What about our next element here? Intent to deceive. Let's see. Joe applies for a job at an accounting firm as an accountant. On the application, he states that he graduated in the top of his class at a prestigious college and had worked at an accounting firm for 2 years in another state. He is hired at the firm. Afterwards, Joe's probation officer notifies the firm that, in fact, Joe has a criminal history and has never done either of those things, and Joe is fired. Can Joe sue for breach of employment contract? Probably not. Knowledge that facts have been falsely represented, or you falsely represent them, or you recklessly make statements that you believe are false, or you just totally disregard the truthfulness. That is an intent to deceive. Scienter is the fancy name for that. But in this instance, Joe cannot win because he clearly made false statements on his application. And then we need reliance on the misrepresentation for us to have fraudulent misrepresentation claim. And you need justifiable reliance. Just not reliance, but justifiable reliance. Dylan, a used car salesman, tells Shelby this old Chevy Blazer SUV will get 60 miles per gallon. Shelby buys the SUV, but it only gets 25 miles per gallon. Can she sue for fraudulent misrepresentation? What is the representation? That the SUV will get 60 miles per gallon when in fact it only got 25 miles per gallon? Is this justifiable reliance? If the innocent party knows the true facts or relies on obviously extravagant statements, it is not justified reliance. So the question is, no one can get that kind of mileage on a vehicle. At least not that I'm aware of. And if you're aware of one, email me and let me know, because I would love to have a vehicle that got 60 miles an hour per gallon. So this is not justifiable reliance. How about the horse example that we talked about with Joanne? There is no way of knowing the medical condition of the horse, but if the intent is buying it for the use of the competition, and he relied on her conduct, then that's justifiable reliance. And lastly, you need an injury to the innocent party. What do you get? You can't have all of those things and not have somebody injured in the end. Because if you get to this point, you're like, well, what did you suffer? What was your injury? So you have to show that you were injured in some fashion to recover. If you don't have this, then why are we here? So what is it that you could get? Let's take the example of the horse. He bought the horse. Let's say he paid $1,000 for the horse, and then in the end the horse wasn't worth $100 because it couldn't even compete. You'd either, one, get the difference in money, the $100 versus $1,000, or maybe the return, cancel the contract. If nothing has exchanged yet, there wasn't full performance on the contract, you could just rescind the contract and return the parties to the original position had the contract not been made, and that would be an equitable remedy. So that is fraudulent misrepresentation. We have undue influence. I believe the next two, undue influence and duress, are pretty self-explanatory. Undue influence, no voluntary consent exists if the party's been unduly influenced. And typically we're targeting, young people and elderly people. So what is it? It is the, do I have it on this? Well, let's do my example. I think I have it up on my next slide here. Susan, Edith's in-home caregiver, and has been for several years, and Edith is 90 years old. So one day Susan convinces Edith to review her will. Together they rework the terms, and Susan convinces Edith that she is more deserving than Edith's two sons, and she also threatens to quit if she doesn't change the will, giving her 3/4 of her estate. So do we have voluntary consent here? No, we clearly do not have voluntary consent here. This is an extreme example. But basically, the definition of undue influence is persuasion that is less than actual force, but more than advice, and that induces a person to act according to the will or purposes of the dominating party. And in this case, Edith was up against losing her health care, her home care provider that she's had for several years. And that was kind of the dominating influence. In that case, there would be undue influence. And then how about this? Duress, sell me your vehicle for $500 or I will kill your dog. That is a extreme example. The unlawful force or pressure brought to bear on a person, overcoming the person's fear. Free will over person's free will and causing him or her to do what she would not otherwise have done. So you sign your vehicle over to me or I will kill your dog. And that certainly would be something that I would do under duress. I have a dog. So being forced to do something, you're being forced to enter into an agreement. There's no voluntary consent here. It uses fear of threats. So harm you, harm your spouse. It may say you do A, B, and C, or I'm going to tell your spouse you're cheating on them, even if that's true or not. That is a form of duress. So that is voluntary consent, and we have covered the legalities, the requirements of a contract, proper form, the legalities, and from here we will work on, from here next week will be the written content. So without further ado.